Good morning, everyone, and a very warm welcome to today's webinar on recent trends in commercial arbitration. We are delighted to have all of you join us for what promises to be an highly insightful discussion on some of the most significant developments shaping commercial arbitration today. Before I begin, I would like to introduce our moderator for the session, Mr. Madhav, COO and co-founder of JustAct, who will be guiding today's conversation and helping us navigate these important themes. It is now my absolute pleasure to introduce our esteemed guest speaker, Mr. Ganesh Chandru, partner at Dua Associates. Mr. Chandru is widely recognized as one of the leading practitioners in the field of arbitration with extensive experience spanning international and domestic arbitration as well as commercial litigation. He is admitted to practice in India, England, and Wales and Singapore. What makes his journey particularly remarkable is the breadth of experience he brings from multiple arbitration jurisdictions and institutions. Over the years, he has advised and represented parties in arbitrations conducted under leading institutional rules such as Singapore International Arbitration, ICC, UNCITRAL, and of course, numerous arbitration proceedings seated in India. His work has covered diverse ranges and sectors, including oil and gas, infrastructure, construction, energy, telecommunication, banking and finance, and other commercial complex disputes. Given today's focus on commercial arbitration, there could hardly be a more fitted speaker for this discussion, as we all believe. Mr. Chandru spent over 16 years in Singapore. During his tenure as a counsel and assistant registrar at the Singapore International Arbitration Center between 2002 and 2007, he supervised administration of nearly 500 arbitrations and played an important role in strengthening its engagement with India, and that initiative's impact continues to be felt even today. Sir, your experience spans the evolution of arbitration across different jurisdictions, institutions, and industries. And we're truly fortunate to have the opportunity to learn from your insights today. On behalf of JustAct and everybody attending this webinar, thank you for taking out the time to join us. We look forward to an engaging and thought-provoking discussion on the evolution of landscape of commercial arbitration, sector-specific challenges, and the growing influence of technology and online dispute resolution in shaping the future of dispute resolution. I would now hand over to Mr. Madhav. Over to you, sir.
Thank you. Thanks a lot, Akriti. It was a nice, lovely introduction. And welcome. Good morning, sir, and welcome to our webinar series, episode 4. It's a pleasure to have you. We have known each other for past 5 years. I think one of the initial and first journeys of JustAct in arbitration world was with you. It was a 7-day long marathon arbitration. As much as it was difficult for us doing case management for you, I think you and the counsels and the parties also had to go through the same turmoil of non-stop every single day. And that time, I think it was raining. It was a cyclone season in Chennai. We were stuck in water.
Very much.
Welcome, sir.
Thank you so much, Madhav, and thanks, Akriti, for that kind introduction. It's really a pleasure to be part of your webinar, and really look forward to this session today with you, Madhav.
Definitely, sir. Looking forward. Just to set the context and just to set the theme of today's flow, we'll be starting with a conversation around the commercial arbitration and trends within this sector for about 40 minutes, 35 to 40 minutes. And we will go for any questions therein from the audience. And we'll close it by about 11:55 today. So without further ado, sir, before we move on or before we step into the first question, I'm sure everyone attending today would love to know your journey. An NLS IU Bangalore pass out lawyer, how did he find himself in Singapore? What was your journey in Singapore, and what pulled you back to your homeland, and the entire experience so far, sir?
Thanks, Madhav. Firstly, thanks to JustAct for inviting me to be part of this webinar. It's excellent. And Madhav, I do recall our session in the Nani Palkiwala Center where we had, arbitrations,
Right.
different time jurisdictions, especially at night. And I was very impressed with the way you all, helped the transcription in that particular
Right, sir.
arbitration. It was a fantastic experience. I'll speak about that more when we come to
Sure.
different questions. But
Sure.
first, I need to clarify I'm an alumni of Madras Law College. While I have been invited to, teach a course at NLS Bangalore, I'm an alumni of Madras Law College. I finished a
So sorry.
5-year course from Madras. That's okay. That's absolutely fine. From Madras in 1994. And since you spoke about NLS, I will also like to clear a myth which many in the country today have, that the 5-year law program, hitherto law was a 3-year law course. And prior to that, till the 1960s, it was only a 2-year law course. I don't know, many will not know that.
Oh.
So you do a first degree, then you do a 2-year law program, and
Mm-hmm.
then once you finish your LLB, 1 year you go through something called an apprenticeship system, and then you do your bar exam. This was there till the 1960s. Then the bar council thought it best to encompass those subjects for the bar exam in the third year of the LLB, which is the
Mm-hmm.
procedural laws, and made it a 3-year course. The 5-year course was introduced in 1983, and Madras Law College and few other law colleges around India actually started the 5 years. They introduced it immediately after the Advocates Act was amended. And NLS started the 5 years course only in 1988.
Okay.
So while the first batch of the 5-year course from Madras Law College graduated in 1988, NLS first batch graduated in 93. So
Oh.
while all credit to Dr. Madhav Menon, who really made the dream come true, that you can have fantastic quality legal education in a 5-year course, which NLS was the first such national law school. The 5-year course was indeed, started 5 years back in Madras and few other law colleges, all of them mostly government law colleges, I would say. And I started my law in 1989 and I graduated in 1994. So that's where I started my practice in 1994 in Chennai at the Madras High Court. And 4 years as a student, I was also interning from 1990 to 94. I was also almost a permanent intern because the law college was just next door. And
Mm-hmm.
mornings we would go to court, and then a lot of us were in the High Court following a senior to learn on the job. And we were doing our classes in the afternoons, which we had about 5 hours of class. So that's where my journey started, from the law college in Madras and the Madras High Court. I practiced in Madras for 4 years,
Mm-hmm.
both in Chennai, and I used to do quite a bit of work in Supreme Court as well for appeals and all that. And I actually moved to Singapore, Madhav, on a research scholarship at the National University of Singapore. And I did a thesis on international commercial arbitration and information technology. And today we talk so much about AI and virtual hearings and all that. I did a thesis on that between 98 and 2000, when things were still, you know, very, very nascent.
Yeah.
That disputes at that point in time used to be domain name disputes, which had
Mm-hmm.
just come up. And the UDRP in the US was forming this domain name procedure, and World Intellectual Property Organization today has a procedure for domain names. For example, somebody registers as mcdonalds.com, but they are not the owners, or it's called cyber squatting. So now there's a clear route for that, where you need to have a trademark and only then you can register a domain name. Now it's all structured. So I did that, and I was also, part of my thesis were also about online hearing and the legality of that. So I
Mm-hmm.
submitted that in the year 2000, and I was conferred my master's by research by NUS in Singapore. And then I stayed on. You wanted me to tell a few words about how it was to be. I mean, I was one of the first, I think, Indian qualified lawyers to have, to attempt to work in Singapore, because then it was the market was not like what it is today. It was very tight. It was only for Singapore qualified lawyers, and very few international firms were there, and most of them were doing corporate work. So nobody was really, international firms were not involved in dispute resolution. So unless you were called to the Singapore bar, you couldn't, go to court or do any disputes work. That was the perception. Of course, Singapore opened up as a big arbitration regime. I first worked as a international lawyer, registered foreign lawyer, with some leading firms. I was with Baker and McKenzie for a while, and I was also with the SIAC for 5 years, as Akriti had told during my introduction. It was a 5-year journey when SIAC was truly, I mean, it became a really, true institution, if you call in that sense, because SIAC was established in 1991, and I joined them in 2002 when it was just 10 years old.
Right.
And we had introduced ad valorem fees, practice notes, all was done during the time that I was heading the case management as a deputy registrar of the center. And I told SIAC that India is a great jurisdiction because, I mean, there's a crying need because most of it is ad hoc arbitration. We discussed, and there was a great support from the center. Of course, it was the center's, support that made me, promote and bring SIAC to India. And I pioneered their initiatives while still keeping my role as a deputy registrar. I made several trips to Delhi, Bombay, Chennai, Bangalore, Hyderabad, and other places, and we really did a lot of workshops. And I left SIAC, Madhav, after 5 years in 2007. I went back to private practice. I was working with leading both Singapore law firms and English law firms. And my last stint was with Rodike as a partner before I moved to Delhi in 2015. But I should say Singapore's journey has been very interesting, which we will talk about during the course of this conversation. And after having, Akriti told me, I mean, I'm sure there are a lot of youngsters listening to this program today. As she mentioned during my, introduction, that I'm qualified in India, England, and in Singapore to practice. But in 2015, when they were going to, when there were talks about the Arbitration Act going to be amended, it was not still amended, but I decided that India is the place where I'll have to be. So that's the reason, and I still believe so. And we will talk about it during the course of this conversation. Yeah.
Sure. First of all, sorry for the snafu on NLS IU Bangalore. It was a disaster from my side. Apologies.
Oh, no, not at all. It's a great law school, but I just had to clarify because I need to be patriotic to my law school. And
No, for sure, sir. Thank you. Speaking of commercial arbitration and how you have started your career in terms of doing your master's and writing a research paper, it has evolved. I'm sure you know better than us, and we would like to know more from you. It has evolved significantly over the past couple of decades. What, according to you, are the most important changes that you see? Drawing parallels from your writings in that particular paper, like you said, case management and the IT infrastructure technology, all these things. So can you please share your experience and share your understanding of how it has evolved over the past few years, please?
I think one thing which has happened in a very big way, it's not just for arbitration, but for dispute resolution overall, including for court worldwide. I think it was the pandemic that happened in 2020, which literally forced us to turn to virtual hearings. We didn't have a choice. If we didn't have virtual hearings, all lawyers would have been, I mean, out of job, and more so for the litigants who needed urgent orders and things which couldn't wait for 2 years. I mean, we saw that as because we always think necessity is the mother of success, because we were forced to do it. It was necessity. So I think, in my view, what has changed a lot in the last, I would say, 6-7 years is the advent of virtual hearings. That's completely changed the way, dispute resolution is conducted, not in just our country, but worldwide. While virtual hearings were still available earlier as well for certain parts of the hearing, it's not the way it is happening today. And on this topic, Madhav, what I would, since we are talking about how it is developed in the last few years, I think now on the virtual hearing, I would like to really focus, because that's something which we are doing on a day-to-day basis. and I feel is a very, very important facet of dispute resolution. I think
Correct.
JustAct, I know, facilitates this in a very big way. You're having transcription services as well as you're providing other allied services for online and virtual hearing. I think what's happened now today worldwide for arbitration, including in India, I would say, is that unless you really need to meet physically for the final hearing, most arbitrators would prefer to do the, let us say, any interim applications or even the preliminary hearing virtually. So you didn't really need to meet them physically. While I would think that now that after the pandemic, people are back doing regular hearings, I find that after the first preliminary meeting, sometimes
Mhm.
the arbitrators may want to meet the parties and the representative of the parties. I think it's only you don't meet physically until the final hearing. So what does this bring us to? The process from the appointment of arbitrator till the hearing itself. I think there are so many things that happen in an arbitration. See, most
Correct.
of it is in writing. So you're communicating by way of email. I don't
Mhm.
think anybody is writing letters physically these days. Even we don't wish people, the New Year cards have become very rare. Everything is done by
WhatsApp.
WhatsApp or by email.
Yeah.
And now communication or writing is always done through email. Even if you have a letter,
Right.
you kind of scan it and you attach a PDF and you're sending it.
Correct.
That's how it works in
Correct.
most arbitrations now. So everything has become, kind of electronic. And be it communication, then you look at pleadings in the arbitration, right? Hitherto, you were submitting the hard copy to the arbitrators all the time. I mean, that was the case. But now most arbitrators are insisting that you just give me soft copies. I don't want hard copy.
Correct.
Even if some arbitrators insist on having hard copies, what we typically do is send them the soft copy and send a confirmatory hard copy, which, in my view, it's also good. The basic pleadings,
Mhm.
I would think, still, I mean, I don't know, many, I do have dialogues with many people. They say, why do you really need? I would feel that in an arbitration, maybe one set at least,
Mhm.
I think it'll be good to keep a physical copy. Because for some reason, some technology, something goes wrong, at least you have something to fall back upon as one hard copy kept maybe in the counsel's office or the presiding arbitrator, the sole arbitrator. It may be good, is my view, but some arbitrators just prefer soft copies, which is very good, and some
Mhm.
ask for hard copies as a backup, so that in case there's something they can quickly refer to it, which is always, I think, at least the main pleadings. Should
Right. Right.
I think you should make the which the client signs. Still, they have a physical signing of the pleadings, and in
Yep.
India also we have this practice of getting it notarized, and anyway you will have a hard copy. So all those, I think, you should safe keep until the award is made, and the matter could go to court. So I think this is, of course, now we are in an era where we are just getting used to all these virtual hearings and electronic documents and all that. What is very important, Madhav, which is developed in the last few years, is you have a virtual hearing.
Mhm.
Right now we are having this conference on Zoom platform, right?
Mhm.
And there are many other platforms. But when it comes to arbitration, right, in many jurisdictions, arbitration is a confidential process, right? In
Right.
India, we have legislated our Arbitration Act. We have introduced a Section 42A, by which arbitration by law is now confidential.
Mhm.
So
Yeah.
it's very, very important for you to maintain that. And I think there are a lot of recommendations worldwide as to virtual hearings. For example, the IBA rules on taking of evidence in international arbitration 2020, in Article 8.2, talks about having a protocol for a virtual hearing. So when these kind of, virtual hearings came about, many institutions came up with a remote arbitration protocol.
Correct.
One of the best was the Vienna Protocol, where they had a practical checklist of what needs to be done before a virtual hearing. What is a remote hearing protocol? Parties agree that this is the procedure that I would adopt when hearing, a matter, before even before the hearing. You agree on what the procedures would be, who would be attending this particular call, who will manage the documents. For example, if let's say we are using JustAct for showing the documents, then who will be the person there? So once it's all done, and if, let's say, an institution like you controls the hearing, then when the hearing starts, they literally lock the virtual room. That is, nobody can really enter without the permission of the manager of that particular hearing. So I think that's very important, because documents, data security, all this is very, 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 very important. So I guess having a remote hearing protocol or a virtual hearing protocol is extremely important. You need to also, in that protocol, tell what platform you'll use for this particular hearing. And it's very, very important. Like, for example, I can tell the audience today that JustAct took a great initiative, as well as their provider, Mr. Vivian. Yesterday we had a test run. Before we did this webinar, we had a test run yesterday. That's exactly what all these protocols, Vienna Protocol and other protocols, tell you, that before the hearing, the arbitrators and parties should have at least one or two test runs. You cannot do it during the hearing. You
Yeah.
need to do it prior to the hearing. Fix up a time, maybe 15 minutes, half an hour, whatever it is, so that when the hearing proper starts, you're not wasting time on these logistics.
Correct.
Right? So that's extremely important. And so that remote hearing protocol is important, because we are doing virtual hearings all the time, Madhav, today. So
And you can
while
also see if it is a mirror image or not also.
That's right. That's right. You can see that. And I think also in that, we have done these things before. During the test runs, what we would do is, very importantly, we will tell, is in many hearings, we ourselves would show the documents, because it's easier. One of the team members is able to navigate the documents and
Right.
show it to the tribunal, which is easier. But sometimes, we also, the the provider does that. They'll put somebody on the job, and they will pick up the documents, and you create something called a hearing bundle.
Correct.
Whatever is filed in the arbitration, you create a hearing bundle, and you have an index which is hyperlinked. You click, you immediately go to the document, and it's all OCR, so you can do a word search with Control F. So it's all, technology is great, but sometimes I do feel that people like us, who are like late 40s and the 50s in age, we
Mhm.
are in a different era. We all started with hard copies.
Right.
Even in Singapore, I think till the last, I mean, we were using hard copies till I left in 2015. I don't think we were using soft copies all the time. It's only in the last, after the pandemic, that everything has become so much of soft copies.
Correct.
While video conferencing was still there then, but what I mean is, the documents, other things, everything was hard copies,
Okay.
right? So now everything has changed. So if this is the case, for a generation like us, still sometimes we prefer to have the, but you talk about the chunk of the legal practitioners today,
Mhm.
who are young, below 40. And I mean, I'm impressed with some of the retired judges who are arbitrators. They are
Correct.
fantastic. Somebody, no piece of paper. They say, we just have a tab and a laptop. That's it. We
Yeah.
don't want you to give anything physical to us. That is fantastic. But not everybody is used to that.
Exactly. Yeah. Yeah.
Even today, if you go to the court, if you go to the Supreme Court, you go to the high courts, most of them are using only tabs and laptops. They don't bring in hard copies, while a group still brings in hard copies. But I think maybe I would say in about 10 years, I would think everything will go mostly paperless.
Paperless. Yeah.
Yeah. But the courts in India are a court of record, so because of that, we'll still have to maintain, certain hard copies in the sections when we file, these. And most is now online filing as well. In fact, Singapore, I was surprised, introduced compulsory, e-filing system in the year 2000.
Mhm.
26 years back, you couldn't file anything in court, just like it has to be filed online. So, and you would give a confirmatory copy by hard copy as well, but your filing has to be done online. The
Okay.
advantage is you could do it even till midnight. You don't need to rush to the registry by 5 p.m. So you could do it. Each lawyer will have an ID and a card and a password, and use that to. Of course, the clerks will do it using your password once you approve it. But still, it's they started that now. Most of the courts in India as well, you'll have to do an online filing, including tribunals and courts. So I think that way we have evolved a lot, Madhav. So
Right.
I think I thought I'll spend good time on this, because this is the most important aspect of the development that has happened today. In terms of, we are talking so much about AI, technology, all that is secondary. First, how
Yeah.
do you conduct this proceeding at the end of the day, which is the process of
Process.
this
Yes.
arbitration, which
Yes.
has gone most of it has become using technology, either for documents or by even for discovery of documents, and
Yeah.
also for the hearing, which has become virtual, including the courts today. Supreme Court, I can sit in Chennai and appear in the Supreme Court. They're not going to say, why are you not here physically? Because the courts say that, please, you are welcome to do it, online, which is fantastic, which has actually saved a lot of time and cost for the parties. See, at the end of the day, a litigant, spending so much of money for them and the lawyer to travel to different places.
Yeah.
Now
Yeah.
they can just come to the lawyer's office like normal and sit with them and participate in the hearing if they want, or they can log in from their respective places. So this
Hmm.
is completely changed the world, I think. Yeah, that's my main thrust, I would say, of
No,
the
no,
change.
great. I mean, it's lovely to know that even in Singapore, about till 10 years ago, or till even COVID, one of the most developed countries, one would assume that there were online or electronic or digital evidence systems in practice long ago, but only COVID can do what it did. So, and which gives me a memory of a few arbitrators and how they practice in India as well. Depending from stenographers, typed output to digital transcription that we are seeing right now happening. Even currently, right now, whatever we are speaking is getting transcribed on the bottom of your screen, if you can see. That is JustAct's transcription. And also, I've seen a few retired judges and arbitrators currently are only presenting evidence as a recording in a USB in the code as evidence. So there is no transcript, there is no written format, only the audio recording or the video recording of the
Yeah.
session.
Yes.
And it is attested by the arbitrator that it was done in front of him or her,
Yeah.
and it gets submitted. So I think very rightly pointed out by you is the process and the process autonomy that people have, that flexibility that the act gives is so important, and it eases rather than makes life difficult for conducting these arbitral hearings. Sir, which brings me to the second point, the procedural autonomy and procedural innovation. In the construction disputes, how have they changed? Do they need to respond to the external pressures? What procedural innovations in the construction energy mean in the sectors would mean?
Yeah. See, one area where there is a lot of arbitration, I mean, worldwide, is
Yeah,
the construction infrastructure sector, especially when I'm talking about big ticket arbitrations, right? So when you talk about infrastructure projects, in fact, India needs so much of infrastructure, though we have developed a lot in several ways. There are so many areas where there's a lot to be done in terms of our infrastructure, be it roads, rails, and
right.
though the government of India has been doing a fantastic job in promoting infrastructure at a great level, but we still see when there is a cyclone or even a normal monsoon, many cities, I'm sorry, including Delhi, Chennai,
Yeah,
we are waterlogged. What are we
yeah,
talking about India shining and India developing when we can't have a road which can't
true.
take a normal rain? I'm not talking about cyclones or hailstorms. We're talking about
Right.
normal rain, right?
Normal rains.
So that's where I think there's an infrastructure crying need for developing infrastructure in the country, and there's so much investment happening in India on infrastructure. And if you have a foreign party being involved, none of them want to go to court. I mean, everybody wants to go for arbitration. And it's the same with private parties as well. It's a lot of arbitration happening in the construction sector. And I think in the last few years, I've seen a lot of engineers also
Hmm.
becoming arbitrators. Though traditionally there are engineers who there's so much that has happened in the last 15, 20 years that a lot of them have attended arbitration training programs conducted
Right.
by the Chartered Institute of Arbitrators and Society of Construction Law. All of them have done a great job in promoting, and having arbitrators from not just the legal fraternity but also from the industry as arbitrators. So when you talk about construction disputes, the biggest problem, Madhav, is when a project is going on, right? Cash flows can be a very big issue. If
Yeah.
parties are going to be at loggerheads in an arbitration, right? unless the contractor and the owner are very having deep pockets, running an arbitration is going to be a very, very expensive affair for them, and
Yeah.
it's also going to stall everything. So I think one thing which has happened a lot now is mediation has taken up, is becoming a big,
Yeah.
in a big way, even in the infrastructure construction arena. And I think, I don't know how much is the success rate, but I think there is a lot of success happening in mediation. And there's also outside expert committee, which most of the public sector undertakings have. It's called OEC proceedings, where a
Mm-hmm.
lot of this is being conciliated, and sometimes they do arrive at a settlement. So I think that's happening in a very big way in the construction arena, not just because of the arbitration is always there, but you need to get quick resolutions. And I think that's extremely important. And even if sometimes there are projects where it still goes on, it is ongoing, and a part of that can be arbitrated, but that is very difficult. Once you are in dispute, you can't do much. That's why contracts have to be drafted very carefully, and you need to have liquidated damages clause, and things as to the thing will still continue. Most PSUs will say, yes, I grant you an extension of time, but I reserve the right to charge you
True.
liquidated damages for the delay. But this is, of course, a question of evidence at the end of the day. In very big projects, for example, let's say subsea pipelines and that kind of project, and very big infrastructure projects, the delay and other things, you will have to have a critical path analysis. And
Correct.
that's where I think, Madhav, one very big change that has happened in recent years in India in the construction infrastructure area is the contribution by experts. You have
Mm-hmm.
subject experts like delay analysts and people who can opine before the arbitral tribunal
Right.
on what was the reason for this delay, and where do you do a proper critical path analysis. For example, there are softwares like Primavera and others which they have to use in the project for
Correct.
saying which party did cause the delay, and they do give daily progress reports, weekly progress reports, monthly progress reports. These all can be voluminous.
Correct.
So therefore, maintaining documents is extremely important. Document management in a construction project is extremely important. So they need to, if it's a big company, they have a separate department which does this.
Mm-hmm.
Your approvals and your letters and the way you write, because at the end of the day, all this can form part of the evidence that you are having in an arbitration. Of
Correct.
course, when you're doing a commercial deal and you're doing a project, you can't keep thinking of when I'm going to have a fight with the other guy and I keep on creating documents, right? So you need to make sure the project is done very well. So you
Right.
need to leave it to a particular department. You have to have that up front. You need to have a few people who will just manage the documents so that the other people can be focusing on the project. And when it comes to important meetings, minutes of the meetings have to be maintained very well. I think most companies now have started doing this and dedicating dedicated resources who are doing this. You can't do it this with a few people. You need to have dedicated people to manage this. Because if you don't do that, then when you get into a dispute,
Mm-hmm.
then it's not going to be that straightforward or easy for you to manage the dispute or present your case well. You need to present your case properly before a tribunal or a court. I think that change is taking place in a big way. And I feel expert evidence now, tribunals in India appreciate that you do need expert evidence in some cases. Some people used to say, why do I need these guys? I can manage it myself. That's not the case anymore. See, many
Right.
people also think if it's a tribunal of three people, it may be good to have one of the co-arbitrators who's a construction expert or an engineer or retired from the government department as a chief engineer or CPWD director. I'm just giving you examples,
Mm-hmm.
which is good, which is fantastic, and they also sit as arbitrators for these kind of cases. But even if you don't have this, and if you have legal people like retired judges or lawyers as arbitrators, you can always call an expert to testify.
Correct.
And experts can be appointed by the tribunal, or both parties can also appoint an expert. And if you have two experts, many a times in international arbitration, Madhav,
Yeah.
they have something called hot tubbing. Hot tubbing is nothing very, I mean, you're not sitting and chilling in a tub or so. It's like, it's called witness conferencing when the two of them are put together and questions are asked. So I
Correct.
guess these are the things which I think these tools are used in construction arbitration these days, which have made it much more efficient. But of course, you can afford this only in big matters. In small matters, I think the arbitrator has to really, pull up their socks and and do the job which sometimes the parties may not be able to afford an expert. So I guess all this put together, construction arbitration is a very, very interesting area in itself. And I think those are the chunk of the disputes today, not just in India, but all over the world in the arbitration field.
No, absolutely, sir. The what you mentioned about witness experts and even the arbitrators being appointed who have relevant expertise instead of how we go to courts and the judges get appointed randomly. You may end up having a judge who is presiding over your case who doesn't know what or anything about the particular subject, and arbitration provides for that. Just a quick small segue into this particular. I wanted to know your opinion in it. Do we see the requirement at this point in time to have different procedures and different sort of sub clauses or sub provisions under the Act, laying down clarity on arbitral proceedings sector wise? I for with a very very limited experience in the ADR ODR sector. I see there is a very huge requirement to have a different sort of procedures in the NBFCs and banking arbitrations.
Yes,
Right?
I think
More
yeah,
than.
yeah. Now that you bring different sectors, be it banking or maritime.
Mhm.
Maritime is another big area where there's a lot of
Yes.
arbitration going on. I
Yes.
think we can combine all that now because I can, because I'm talking
Please.
about sector specific. We spoke about construction,
Right,
and
sir.
see, I feel the arbitral legislation, okay, we shouldn't tweak too much with our arbitration act. That's my personal view.
Okay.
If there's a crying need, you do it. You need to have a basic act, right? We have an arbitration act uh, which has gone through several amendments. We'll speak about that when we talk about the UNCITRAL and other things.
Okay.
But what I feel is the statutes should not have sector-specific, provisions in the legislation itself. Arbitration legislation, we should all first understand, is a procedural law. It says how an arbitration is conducted. It's not a substantial law, right?
Correct.
Substantive law, things like Contract Act, for example, which deals with issues arising in all facets, be it maritime or construction or NBCCs and all that. These financial sector arbitrations, there are several of them going on, and it's all most of them very small, in this in terms of the amount in dispute,
Claim values. Yeah.
claim value. Predominant over cases are extremely small value cases. So I guess
Correct.
some of the institutions are specializing this and are doing it pretty decently, I feel, at this point in time, because if all these come into the court system, the already overloaded
Overloaded.
court is going
Yeah.
to be much overloaded with much more smaller disputes. These disputes, in my view, should not even go to arbitration.
Correct.
They should have some other method, like an
Mhm.
expert determination or a quick resolution, which I think is still done, but they call it an arbitral award. So that's
Mhm.
how it is all done, whether you pay or
Right.
you don't pay, right? It's like
Yeah.
a summary trial in a court. I mean, you don't have a defense, you just have to say, what do you say? Is there any issue? Otherwise, you just pay up. As simple as that. So they'll
It
have to
needs
just
to be.
enforce
Yes.
the award. So I think this is a method they are using so that they have an enforceable award, because an award can be enforced like a decree of court. I think that's an industry which is a separate baby in itself, and it's going on in a very big way. And I think it's volume based work, right? But
Yes.
when it comes to construction, maritime, and even shareholders dispute and other kind of big commercial arbitration, see, we'll have to put arbitrations in three buckets. One is the big ticket arbitrations, which are several crores in dispute,
Mhm.
and the mid-sized arbitrations, which probably is above a crore and not that big, but few crores. And then you have these small claims, which form the majority of these NBCC and financial. For example, somebody takes a loan for buying a moped or a scooter, and there's a clause there in that loan agreement. He may just sign it without even knowing that the clause is there. Half of them don't even bother reading it up. And then when they default, then you get a notice for arbitration, and you
Yeah.
either pay up or you have a. So I'm just giving you an example. So
Most of
this
us
is
don't read the loan documents, huh? I mean.
so I guess this is these arbitrations are going on, but I think what we are bothered here about is I'm not saying that is very important facet of dispute resolution as well, but what we are talking about for transcription and other services and having a big commercial matters, I think that's a completely different area of I would say kind of an arbitration practice, which is which is in my view a little more, I wouldn't say everybody needs sophistication, whether it's small or big cases. Whether you conduct a case before the small causes court or the Supreme Court, in my view, the lawyer has to put the same effort because it is a court of law, right?
Right.
Similarly, whether the arbitration is only, a few lakhs or with several $1 million, the
Correct.
effort from the lawyer, in my view, has to be the same because you are dealing with a dispute, right? So,
Mhm.
therefore, but how much can a client spend? How much can you put in effort? It depends on the amount in dispute as well, because otherwise it doesn't make the commercial sense for the parties, right? So, I guess these kind of different arbitrations are happening in the country. There's so many arbitrations taking place in India, and most of it is ad hoc. So, we do not even have proper statistics of these. So I guess it's a very, this is why they want to regulate all this. A lot of steps are being taken, but let's see how it goes. Yeah.
No, absolutely. This brings me to a point on UNCITRAL, like you initially in your answer mentioned. So I'm going to quickly club a couple of points, and there is
Yes.
also one of the audience questions, which is very relevant to the
Sure.
upcoming question, sir. Is the UNCITRAL model being adopted in drafting our own arbitration act in India?
Yes.
What and how it has shaped arbitrations in India? Based on this, the recent CJI's remark on how now arbitrations in India are more akin to a litigation, cost-wise and procedurally, they get adjournments every now and then, and arbitrators' costs have gone skyrocketed. Which again, Gujarat High Court is going heavily on, trying to curtail the pricing of arbitrators. So all these things, I want to club everything in one question because of the paucity of time. I'm sorry.
Sure, sure,
Um,
sure, sure.
but yes, I'm sure it will.
I'll be quick on this because but it's a very important topic actually, because see, India, let me tell you, we had an 1899 Arbitration Act, right, based
Mhm.
on the then English arbitration. I'm talking about the modern arbitral legislation. I'm not talking about historically we always had mediation and panchayats. From time immemorial, we've been having village and elders settling disputes. But the modern common law British, after they colonized India, 1899, there was an English Arbitration Act, which was based on the then English Arbitration Act. We had an Indian Arbitration Act in 1899. Then we had
Mhm.
procedures in the Civil Procedure Code on arbitration. Then we had a 1940 Act, which was
Correct.
again based on the then British English Arbitration Act. And 1940 Act was holding the fort for till we had the 96 Act, right? And then India signed the New York Convention, the 1958, the recognition and enforcement of foreign arbitral awards.
Right.
Before that, we had a Geneva Convention as well, which India signed when we were British India in the 1930s, and we did have an act in India ratifying that in 1937. Okay, but that's why if you look at our Arbitration Act, there'll be one schedule for New York Convention, one for the Geneva Convention. Till date, we have that as part of our act
Yeah.
because there were certain countries and India was part of that. Now we have the New York Convention with several countries. I think more than 150 are signatories to the New York Convention. An award made in one country can be enforced like an award made in the other country. So you can just take it and enforce it like a as freely, and it's such a fantastic piece of I mean legislation in India, because we legislated a 1961 Foreign Awards Act based on, because we signed the 1958 convention, we had to ratify it. All this is now encompassed, all this is gone. We just have the 1996 Act.
Mhm.
Why? What does 1996 Act do? It followed the UNCITRAL. UNCITRAL is the United Nations International, Commission on International Trade Law, UNCITRAL,
Right.
which was created in the I think if I'm not mistaken, 1966, under the General Assembly of the United Nations. Right? It's a specialized organ headquartered in Vienna. It
Correct.
also has offices outside in New York and other places. And I think UNCITRAL has done a fantastic job by propounding model laws. As you would say, the word model is for somebody to follow when you legislate. India opened up its economy in 1991, but the way it happened was so quick, people didn't even realize what
Yeah.
the opening of the economy was, and everybody said, what dispute resolution procedure do you have in your country if I want to come and invest in your country, right? So
Correct.
immediately everybody said, oh, there is this model law. In fact, the 1996 Act came by way of a presidential ordinance. The entire legislation was a presidential ordinance in 95, which became an act in 1996.
Right.
When I started practice in 1994, Madhav, we were following the 1940 Act, and arbitration for junior lawyers was a party. Because we'll have a hearing, and after that, 2 months later, we'll continue excellent food from some excellent restaurant or five-star hotel, and we'll do it in a hotel or in arbitrator's office. And it was basically, when it's arbitration, it was for like a break, which is very unfortunate, isn't it? It is a dispute resolution, but from the 1996 Act, the greatest difference in India that this brought about is under the 1940 Act, if you have an arbitration award, you still had to go to the court and get a decree in terms of the award. So the court will still look at the award and see whether it is okay or not. But under the 96 Act, you can enforce an arbitral award like a decree of court straight away. Don't it is like a judgment made by court, akin to that. Unless, of course, the other party is going to challenge it on very limited grounds under Section 34 of our Act. This exactly mirrors Article 34 of the UNCITRAL model law. So I think model law is excellent because if India follows the model law, Singapore follows the model law, right? So when you see judgments coming out of court from arbitration cases from these model law countries, it'll be very similar because there's a lot of harmony in the legislation. But then what we did in India is 1996, we followed the model law and enacted our act. But then we had to make amendments because of the way the act was being interpreted. I feel the 2015 amendments are a great boon to the Indian arbitral legislation, because now you need to make an award within 12 months from the close of pleadings.
Right.
When the 2015 Act was amended in 2015, the Arbitration Act, it was initially 12 months from the time the arbitrator was being appointed, but then that changed to being 12 months from the time the pleadings are completed. This amendment took place in 2019. That was because people were feeling it was very, very tight. This time can be extended by up to 6 months by agreement of parties. Both parties agree it can be 1 month, 2 months, but maximum 6 months. Beyond that, you have to go to court under Section 29A of the Act and get an extension of the mandate of the tribunal. When the court does that, the court can look at it whether the arbitrator was efficient enough. Mostly, I would say, in my experience, the court would, of course, give some leeway there to extend the mandate of the arbitrator. I know we have about 8 or 9 minutes more for 12, but I'll quickly wrap this up to say that yes, model law is great, it's fantastic, but I would always think that in my experience in the last 5-6 years after this timeline has been implemented, I think most of the arbitrations are being finished within 2 to 3 years, even if they get an extension. So you're looking at 18 months, 12 plus 18 months from pleading. For pleadings, we also have a limit of 6 months for the pleadings in the Act. So you're looking at maximum 18 to 24 months for the arbitration to complete. And most of our cases, I think, do complete within 2 to 3 years. But unfortunately, when the Act was amended in 2019, they said this time limit will not apply to international commercial arbitration strictly seated in India, which is good because in some institutions they want more time. But I feel some of the international arbitrations are prolonging because of this escape that they can have, because that strict timeline is not applied to it. But I think this is a sea change. I think this completely changed the landscape. And I would also say, in terms of cost, most arbitrators follow Schedule 4 of the Act if we request them to do so. There's a Schedule 4 in our Arbitration Act, which is an ad valorem fee. And the maximum fees, even if your case is like several $1 million, is only 30 lakhs for a claim, and a separate 30 lakhs for the counterclaim based on the Supreme Court judgment. It said if it's a counterclaim, you have a separate 30 lakhs. So, of course, in my view, it has to be one total amount in dispute, adding both the claim and counterclaim, and you can keep the limit maybe as 60. But anyway, I would still think that there has been a lot of change that has happened, especially the last 5 years to 10 years. I think after this amendment, the arbitrators are all extremely quick. They do finish the matters. I'm talking predominantly. If it's a very complicated case, obviously you need more time. and may have 3 arbitrators, their diaries needs to match. So therefore, there's a crying need of getting more arbitrators in the country, right?
Yeah.
Only then we can achieve all this. Yeah, but I think I would definitely kind of agree that yes, hitherto there was a problem, but today this problem is in only few cases, in my view. If you take 10 cases, maybe 2 could be problematic, but most of the others, I think it finishes within 2 to 3 years. And it also, I think, in terms of the cost, if you follow a fee schedule, you need to be upfront with the arbitrator in the preliminary hearing and say you want a schedule for followed. If that is not done, then of course, I mean, you need to agree to a different method, but have clarity right in the beginning.
True. True, true. Um, Although I've seen a lot of cases getting dragged beyond 3 years, and it's one of drawing from the comment of CJI,
Yes.
Surikant sir, that the parties like to get adjournments and they just come into the meeting and they say, we are not prepared, so another adjournment. And it's a 5 minute meeting, and the entire party, arbitrator, everybody is, running around just to arrange for those 5 minutes of the hearing, only for the council to come and say, we're not ready, I want another hearing date. So
Yeah.
I think it's
No, I
it's a
think I
part
think
of
that
life.
that's just one more point I'll add there. I think the CJ is correct. I mean, he's very right in saying this. It does happen many a times. That's because in India we don't have that many full-time arbitration practitioners.
Correct. Yeah.
For example, if I have an arbitration that week, I'm not going to take any court cases that week. You will have to make that, kind of a choice whether you want to be in court that week or that particular day, or you want to go for arbitration. You cannot have a hearing starting at 5 p.m. and finishes at 8, and then you pick it up every day. In fact, that matter
Right.
that we did, we started late because we had American witnesses in
Right.
the US.
Right.
Otherwise, we typically start an arbitration at 10, 10:30. Even you start at 11, it's okay.
Correct.
But do it during a day. In fact, the
Daytime.
Arbitration Act 2015 amendment specifically has a provision saying it has to be done on a day-to-day basis.
Right.
And adjournments, if they're asked without cause, can be asked. The arbitrator can, impose cause. But the arbitrators sometimes are also practical, because most of the bar is the litigation bar in India. Everybody wants to run around. We
Correct.
started an arbitration bar in India. I mean,
Yeah.
with due respect, the people who run this arbitration bar are busy litigators, right?
Very.
They're
Yeah.
excellent lawyers. They're doing arbitration, but they're very busy litigators.
Correct.
So how are they? How is it that will they leave court and do arbitration whole day? I don't know. Some of them may. I know many of them who do that now, but predominantly none of them want to really. That's why the clients have to be very conscious of appointing people as lawyers who are going to dedicate full time to an arbitration matter.
Yeah.
Right? I think many law firms now have dedicated arbitration teams, not just my team, but I'm sure there are other, I'm 100% sure, not just the, mainstream law firms, but there are also other mid-sized law firms which are now developing, lawyers who will do arbitration on a full-time basis if that is the case for a particular day. We can't in India avoid court, because even for arbitration related matters, we need to go to court. So
Correct.
therefore, I think we'll have to make that. And I mean, you're very right, Madhav. At the end of the day, it is. That's why sometimes in the worldwide, in conferences they say, "Do you really need party-appointed arbitrators?"
Yes.
Because if you have party-appointed arbitrators, sometimes there's a perception that the arbitrator is obliged to the parties because the appointment comes from them. But when
Correct.
you have the appointment done by an institution or the court, the arbitrator can be much more strict. That's a perception, but I don't believe that. I still think arbitrators, in my view, of whatever I have seen, have great integrity. And I
Mhm.
think even if parties appoint them, if they are strict, they can be really strict with
Yeah.
timelines and other things. But I think sometimes you have to give that flexibility, because you do understand and appreciate the problems of counsel sometimes. So I
Yeah.
think it's a mix and match, but I guess the situation has improved drastically from what it was before the 2015 amendment. I can definitely tell that.
I'm hoping it will keep getting better, and one day India actually becomes the hub for all commercial arbitrations in the world. So, having said that, I think so. We have reached the end of our
I,
1 hour.
I'll only, yeah, thank you. But one thing I want to make, when you said India will become a hub for international,
Mhm.
I wish it happens. But first, my view. I think I want to be very, very frank and candid here. First, we should be a good seat for arbitrations conducted in India.
Right.
I think that's extremely important. Parties should have confidence. We should first be a good seat for our domestic arbitration and those international arbitrations that are conducted in India. I think for two parties absolutely not connected with India to choose a seat in India
Yeah.
will happen only if we can, say, and we cannot have India as a, though we may say India, it has to be few cities in India. You
Right.
cannot say India will be, I mean, like Singapore, London, or Hong Kong are very small places. So they are superb in terms. So we are probably talking about, I'm not being geographic, partial or whatever, maybe Delhi, Bombay, Chennai, Bangalore, Hyderabad, Ahmedabad, and few other places where it's more commercial. You know, I know you are a maritime, you have a maritime background as well, Madhav. In fact, Gujarat has come up with the Gujarat Maritime Arbitration Center. I'm
GMAC.
actually one of the GMAC. I'm one of the advisors for them. But
Correct.
this institution is still not. It takes time
It's not
because
picked
parties
up.
have
Yeah.
to. Yeah, parties have to adopt. Same with other institutions like IIAC, of which I was a part-time member. I mean, these
Correct.
are institutions which are young and they are shaping up. So institutional arbitration is the way forward in the country. If that happens, I think all this will completely be put to, we need more institutions, and institutions
Mhm.
that exist have to be promoted in a great way. I don't
Absolutely.
think we had enough time to talk about institutional arbitration, but I guess
No.
that is the key to success in arbitration in India. That has to happen in a very big way.
No, absolutely, sir. And I think it'll take another hour for us to discuss only on the institutional arbitrations and the require and the need of the hour, right? At this point in time, if we were to see ourselves to be the global leader, or even as you said rightly, even giving confidence to Indians about arbitrations within India, and it's a long way to go, I'm sure.
In fact, Madhav, if we had a good institutional arbitration framework and we had
Hmm.
fantastic accredited arbitrators, trained arbitrators who are on the panel, who conduct cases in a very professional way, and I'm sure they're doing it right now in the ad hoc scenario, but there's no institutional oversight on that.
Right.
I don't think the government of India would have come up with a circular a couple of years back where they said that for procurement projects about 10 crores
10 crores,
first
yeah.
attempt mediation and don't choose arbitration.
Right.
This is drastic because there's so much criticism about that worldwide, saying you want to on one hand promote arbitration, on the other the government is saying that about 10 crores don't have arbitration clauses. But you cannot completely blame the government as well, because the system which is there prevalent right now
Right.
is not. But then it is like it's like the other end of the spectrum. You can't do that. I mean,
Yeah.
what they should do, which in fact I think all stakeholders have been telling and impressing upon the government, which I'm sure a lot of people have spoken to them, saying that yes, you might want to protect your interests because of the current scenario that's happening, but instead of doing that, say you cannot do non-institutional arbitration. You cannot have ad hoc arbitration.
Right.
Have institution arbitration and ensure you have fantastic institutions. And I think, my view, Madhav, it will happen. It has to have
Administration
happened.
is important. Yes.
It is important, and if this corrected, and if it says institutional arbitration and we have excellent institutions, I think
Right.
it will take a couple of years for them to reverse this. But I mean, I think the damage, in my view, to a certain extent has happened in the perception of this among the stakeholders. But still, you go to any high court, they're filled with Section 9 applications and Section 11 applications for appointment of arbitrators. Still, a lot of work is going on. But I think this will have an impact. But I think the quicker they correct it, I think it'll be good for the arbitration landscape in the country, which I hope they will. I am very positive about it.
On that positive note, I think we have taken more time than we asked for from you. I'll hand it over back to Akriti. Thank you so much, sir. It was amazing. It was a really wonderful session to catch up again with you and have this conversation, pick your brains on your expertise and your subject knowledge. Thank you so much, sir. It's a pleasure to have you on our webinar.
Thank you so much. And I would say to all the youngsters and other young lawyers who are listening to this, that India is a great place for arbitration. There may be a lot of problems And I think people are speaking from experience of what is the real issue. I think if the arbitration culture has to improve and we have to make it a success, it is in the hands of the younger generation of lawyers and arbitrators. And I think that will definitely happen. We just need a bit of time, and I'm very, very confident it will happen, and we'll become a great center first for domestic arbitration, and then we can dream about becoming an international commercial arbitration hub.
Definitely. Akriti,
Yes,
over to you, please.
right, sir. So as we come to the end of today's session, I would like to extend my sincere gratitude to Mr. Ganesh Chandru for sharing his valuable time and experience and insights with us. So your perspective on, the importance of virtual hearing protocols and the unique challenges which are faced in constitutional and construction and infrastructure arbitrations and the dispute resolution thereof have given us something to reflect on. We have also spoken about, the evolution of the Arbitration Act from the 1940 Act till what we have today. And your discussion on all these aspects have particularly been enriching and given us to reflect on upon lots. I would like to thank our moderator also, Mr. Madhav, for expertly guiding the conversation and facilitating such an engaging discussion. More importantly, thank you to all our participants for joining us today. On behalf of JustAct, we hope today's session has been insightful and thought-provoking as well. We look forward to continuing these discussions and bringing more knowledge sharing opportunities in future. Thank you again, sir, and thanks everyone for joining.
Thank you so much.
Thank you, sir. Thanks, Akriti.